I appreciate the time here, and a quick question, because when we travel overseas with the Foreign Affairs Committee, I often have conversations with foreign leaders about issues that go to the heart of the importance of rule of law and the role that it plays in encouraging foreign investment and the role that it plays in political stability, and how badly these foreign nations need the rule of law, need the credibility that comes with it. So it's a little bit of a shock to me that on our own shores we have blatant examples of discretionary choice and political influence running afoul of the rule of law. You know, in Europe in the 30s, there was this concept of fluid law, and it didn't work out very well. The rule of law for the United States has been sort of a cornerstone. So you get into these areas with fluid law. The SIFI designation process is just one I'd make an example of. I appreciate several of my colleagues raising this issue this morning. I worry that the costs of what economists call here the cloud of political risk that comes into play. Professor Zwick referenced this. This is one of the consequences, this is one of the mistakes in Dodd-Frank, one of the things that we did not get right. And that effect could be permanent. It could be long-lasting. And so, Mr. Gray, we've seen how the CFPB has strayed well outside of its legal boundaries, expanding its reach now into telecom companies and seeking information protected by attorney-client privilege, and even indirectly trying to regulate auto dealers and so forth. Given the agency's design, are you surprised by any of this behavior?
Surprised because there's nothing to constrain them. There's no check or balance. There's no operation of the separation of powers that would conduct an oversight role to rein them in. The White House can't do anything about it. The Congress can hold hearings, but they're not supposed to review the budget. That statute, as I recall, actually says the Congress can't review the budget. I don't expect anyone's going to be arrested for doing so, but the budget's not in your hands, and that's where your power comes from. The courts are required to defer to whatever the agency wants to do under the Chevron doctrine. That's true even in the case of rulings, say, on what's abusive. The agency has refused to spell out what the law means by notice and comment rulemaking, which is the hallmark of American administrative law, one of the geniuses of post-war development. It's going to be, I know it when I see it. It's going to be an ad hoc decision made after the fact, and so nobody knows before they're zapped.
It's going to be fluid law that's constantly evolving, constantly requiring new interpretations by the regulatory community, constantly causing costs out there, compliance costs. This is one of the reasons I opposed Dodd-Frank. But there's another aspect here that I would just, and the Chairman is well aware of this as well. It's the fact that the prudential regulators have the responsibility for safety and soundness, and taking them out of this equation and not allowing them to weigh in on these decisions also has a long-term risk in terms of the first responsibility, which is safety and soundness. And we have, you know, if we were smart, what we would have done was put this function underneath the prudential regulators. It might surprise some to know that every former prudential regulator that I talked to, whether Democrat or Republican, felt that this was a profound error.